Hello and welcome to this session in which we will discuss remedies under the Uniform Commercial Code. Now bear in mind we already discussed remedies under the common law. In this session we'll focus on the UCC. But what are remedies in general? Well, remedies or contract remedies are legal solution provided to a party in a contract when the other party breached the contract, did not comply with the terms of the contract. And these remedies, the purpose of these remedies is to address and correct the harm or the loss caused by the breaching party. Remember, the goal, the aim of the remedies is to either compensate the injured party or in some cases enforce the performance of the contract as originally agreed. So that's the purpose of it. Either you incur the loss, I'm going to compensate you, or force the other party to actually perform. In this session, we're going to break the remedies into what's available for buyer and seller, what's available for seller, what's available for buyers. Now, many of the remedies are the same as common law. When the two are the same, we usually don't discuss. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, FarhatLectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
Let's start by discussing anticipatory repudiation. What is that term? Well, it's a term in contract law where one of the parties, either the buyer or the seller, tells the other party before they are supposed to fulfill their obligation that they will not be able to perform their duties as per the contract, either to perform, to deliver, to pay, whatever it is. They cannot perform their obligation. What would that give to the other non-breaching party? The party that's willing or already performed their obligation, who's not backing out. Well, they give them the right to sue them. The breaching party can decide to take legal action right away for the breach of the contract. They can, guess what? Cancel the contract. They can, you know what? I'm going to terminate the contract because you are not willing to perform your share of this. You could demand assurance, asking for some guarantee that the other party will perform as agreed. You could just basically ask them, I want the assurance that you are going to perform. And we're going to see what's going to happen. We talk about demanding assurance shortly. Or you could wait and see what's going to happen later and sue based upon their action. So the non-breaching party can wait until the date of the performance. If the breaching party fails to perform, then you will sue. You have all these options. It's important to note, though, that the party who will not perform has the right to retract their repudiation as long as the other party has not relied on that, such as by filing a lawsuit. So they can back out of it. They can, you know what, I'm going to go ahead and perform. Let's look at an example. Let's assume Company A contracts with Company B to deliver 1,000 widgets by June 1st. On May 15th, basically 2 weeks before, Company A informed Company B that they will not be able to deliver the widgets. This is an example of anticipatory repudiation. Company B now have several options. They can sue immediately. They can cancel the contract. They can demand assurance. Company B can ask Company A for some form of guarantee or plan that ensures the widget will be delivered on time. Or they can wait and sue later. So Company B could wait until June 1st. If Company A fails to deliver, then sue them. Now, if before June 1st, Company A can inform Company B that they will be able to deliver the widgets after all, and Company B has not taken any of the above action, then Company A repudiation is effectively withdrawn. Another remedy for buyers and sellers is demand assurances if there's reason to demand assurances. So under the UCC, there's a provisions allowing a party in a contract to seek reassurance of performance. Reassurance means, why don't you just reassure me you are going to perform? If they feel there are justifiable reason to doubt the other party's ability to fulfill their contractual obligation. You might be saying, under what circumstances this could happen? Well, there's a word on the street that, your company is going out of business. Or you and the same company have the same supplier, and the supplier is telling you they haven't paid me in the past 6 months. They are not really, they're having some financial difficulties. So that's why you want to seek reassurance of performance. This is particularly relevant when there's a sale of goods. You're delivering product to me. So when one party becomes concerned for one reason or another that the other party may not perform as required, they have the right to request in writing an assurance that the other party will meet their obligation. However, this request has to be based on reasonable ground, meaning there should be valid, some real reason for their concern. If the party from whom the assurance is sought fails to provide a satisfactory response, let's assume they kept dodging the question, they didn't want to answer, this lack of response is considered what? Anticipatory repudiation. It means they're getting ready to breach. In this context, the non-responding party is presumed to have already breached the contract even before the actual time of performance has arrived. Let's take a look at an example. Let's assume Company X has a contract with Company Y for the purchase of raw material with delivery scheduled for July 1st. Mid-June, Company X hears rumors that Company Y facing severe financial difficulties and they're going out of business. Now, obviously, concerned that Company Y will not be able to deliver, what's Company X going to do? They're going to send them a request asking them for reassurance that they are going to fulfill their part of the contract. If Company Y fails to respond to this request with a reasonable time, a week or a few days, their silence indicate what? That they cannot perform, therefore considering anticipatory repudiation. Think about it. If you ask a company, say, are you going to perform? And they are actually going to perform. They say, of course we are going to perform. Why would they not reassure you? In this scenario, though, Company X would assume that Company Y will not deliver the material and could take appropriate action or make alternative arrangement. Because think about this example. Why do you want to do so? You need raw material for your production. You cannot wait for them. Therefore, you want to get going. You want to know if there's any problem, because you heard there might be some problems, and you want to take care of it. Let's talk about punitive damages and duty to mitigate. Just like under the common law, punitive damages are not usually allowed under contract law. So under the UCC, punitive damages are not an option. Similar to the common law, punitive damages are what? Additional sums of money awarded in a lawsuit as a way to punish the defendant for something that they did, harmful behavior, and also to serve as a deterrent for others. Again, in cases related to the sale of goods under the UCC, these are not allowed. Also, under UCC, just like under common law, we have this principle that's called duty to mitigate damages. This duty applies to both buyer and sellers of the contract. What does that mean? It means that if a breach of contract occurs, that's fine. Now, both parties are required to do what? Required to take reasonable steps to mitigate, to reduce the damages resulting from the breach. So if they sent you damaged goods, damaged raw material, don't keep using those damaged raw material in your manufacturing process and complain and keep suing them and asking them for more money. Just stop it. The raw material wasn't good. Find alternative. Or in the case of common law, I always give this example. If the tenant break the lease and they leave, and you have the right to collect for them for the remaining of the lease, legally you can, but you should try to find a tenant to replace them. Essentially, they cannot claim compensation for any damages that they could have reasonably prevented or minimized. So if the raw material is damaged, stop using it in your production process. Let's take a look at an example. If a seller fails to deliver goods as agreed, the buyer should attempt to find a similar product from another source to avoid significant losses. If the buyer simply waits and incurs greater losses without trying to find an alternative, you can wait. You know what? I'm going to wait for them and I'm going to sue them. I'm going to ask them to compensate. No, you should find an alternative solution. They may not be able to recover those additional damages because they did not mitigate. That's why you have to mitigate. The court's going to say, the judge is going to say, well, you had other alternative. Okay, yes, they did break the contract. They did breach the breach determined the contract, but you had other solution to reduce all these losses. Why didn't you take this? So if a buyer cancels an order, the seller should try to sell the goods to another buyer to minimize losses. Same concept. The seller cannot just hold onto the goods, incur more losses, than try to claim all these losses from the original buyer. They should try to sell them and minimize the losses. Now let's take a look at some seller's remedy. Who's the seller? The person that's making the sale. When the buyer breaches the sales contract, the seller has several rights under the UCC to address the situation. These rights are remedies for what? to ensure fair treatment and compensation for the seller because the buyer breached. The first thing that they can do, they can cancel and sue for damages. If the buyer breaches the contract, the seller can choose to cancel, which is rescind the contract, and may also sue the buyer for recovered damages under the breach. For example, a buyer backs out of the contract to purchase furniture. The seller can cancel the contract and sue the buyer for lost profit from the sale as well as incidental cost. What else they can do? Well, if they have not delivered yet, they can stop the delivery. If they're the seller, if the delivery in transit, they can stop it as well. The seller may withhold delivery of goods if the buyer fails to make the required payment or indicate they will not honor the payment. Either or, stop delivering. Additionally, if the goods are in transit, the seller can stop them. Now, example, a buyer fails to make a payment for a batch of electronics. The seller, upon learning this, can stop the shipment that's currently en route to the buyer. Just stop it. That's what they can do. What else the seller can do? Well, they can resell the product and sue for any damages. If you resell and get, more money, or you recovered your losses, you're gonna have hard time suing for damages. But if not, you can sue for damages. So if the buyer breaches the contract, the seller has the right to do what? Resell those goods. The seller can also sue the buyer any losses incurred, and the losses will be typically the difference between the original contract price and the resale value. So if the original contract price was for $8,000 and now you can sell them for $5,000 because you did not sell them at the right time because you assume the other party is going to buy them, there's a $3,000 difference. You can sue for that. Also, you can sue for additional costs like storage, resale expenses, or any incidental expenses. A buyer breaches a contract for 100 custom-made chairs. The seller resells them at a lower price and sues the original buyer for the difference plus additional storage fees. Remember, those chairs are custom-made. It means maybe the name of the buyer is printed on them, or they are specially made for this client. So you're not going to easily find another buyer, so you may sell them at a discounted rate. If that's the case, you can sue the original buyer for damages. You could also sue for full contract price. The seller here can claim the full contract price plus additional damage in situations where the goods cannot be resold. So notice here, those chairs were custom made, but somehow we're able to sell them. Sometime we are selling something, it's custom made for this client. Then guess what? I want my full price. I cannot sell it anymore. You're going to have to pay me. Or if the goods are destroyed after the risk of loss has passed to the buyer. Well, if the risk of loss passed and they were destroyed, it's the buyer's responsibility. So a buyer ordered a custom sculpture, then canceled. The sculpture being customized cannot be resold because it's to your taste. So the seller can claim full price from the buyer. I mean, maybe they will try to sell it, but it's custom made to them. Let's talk about liquidating damages. What are liquidating damages? Those are clauses in the contract in case one of the party breaches. What is the penalty? A liquidating damage clause in contract is enforceable if the amount is reasonable. Remember, the amount is reasonable means you are not trying to penalize the other party. It's reasonable in relation to the anticipated harm from the breach, and it's not punitive, because under contract law, you should not have punitive clauses. Now, if there's no such clause in the contract, this is a little bit different than common law, okay? The seller, remember here we're talking about the seller, can still keep the lesser of $500 or 20% of the contract price. Now, assuming the buyer made a down payment and then breached, so they can keep that. So the maximum they can keep is $500 or 20% of the contract price. So if the contract price is $2,000, that times 20%, we're talking about $400. Well, if the amount was $10,000, 20% is $2,000, then they will keep the $500, the lesser of these two. And this is different than common law. Example, a contract for a large appliance included a liquidated damage clause for $300 for cancellation. If the buyer cancels, the seller can keep this amount if it seemed to be reasonable compared to the harm caused by the breach. Now let's move from the seller to the buyer's remedies. Under the UCC, the buyer also have specific remedies in case the goods delivered to the seller do not conform to the contract. Remember, we talked about perfect tender. The buyer should have a perfect tender, especially in the UCC, sale of goods. So if somebody sells you something, well, it has to match exactly what they said they will, which is different than services. Services because it requires judgment, professional skills. It may not be as in quote accurate as sales of goods. And these remedies, for the same reason for the seller, is to ensure that the buyer in this situation is protected against losses resulting from the seller's failure to deliver the goods that conform to the contractual obligation. The buyer's tender is perfect tender. Not any non-conformity, you're out. So what can the buyer do? Reject any non-conformity. The UCC requires that the seller makes a perfect tender, meaning the goods delivered must, we don't use that word a lot, exactly as specified in the contract, without any defect. If the goods do not meet those standards, the buyer have the right to do what? Reject them. Reject all of them, some, or just accept if they want to. The buyer can sue for damages resulting from any non-conformity. Typically, the buyer has the right to inspect the goods before making the payment, except in the case of what we call COD, cash on delivery sales, because the person that's delivering, they don't want to wait until you inspect the item. It may take a long time to do so. For example, a retailer orders 100 laptops of a specified model but received 90 of the correct model and 10 of the different, less expensive ones. Well, the retailer can reject the incorrect laptops and accept the 90 correct ones or reject the entire, because now what they can do, it's non-conformity. They can do whatever they want to. They have few options here. Also, the buyer have the right to cancel, or rescind the contract. If the goods are non-conforming, the buyer can cancel the contract and sue for damages that result from the seller's failure to deliver what was promised. For example, a restaurant orders custom kitchen equipment, but the items delivered are not specified in the contract. For example, a restaurant orders custom kitchen equipment, but the items delivered are not as specified in the contract. The buyer also have the right to sue for damages. Now, sometimes what they do, they accept the non-conforming damages and they go ahead and sue for the difference. For example, the buyer can accept goods that do not meet specification and sue for damages. And what are the damages? It's the difference in value between what they specified in the contract and what was actually delivered, and they can add incidental and consequential damages or cost. For example, a boutique accepts and keep less valuable dresses that differ from the sample approved and sue for the difference in value. For rejected or undelivered goods, so you received the good, you rejected them, or the goods were not delivered. Okay? What happened here? The buyer can buy similar ones, so a buyer can reject / or if the situation is undelivered goods, the buyer can buy similar ones to cover and sue the original seller for the cost difference and any incidental cost. Remember, you could always add incidental cost, but they have to be reasonable. For example, a business not receiving ordered machine buys a similar one, more expensive, because that's what they could find, and sues the seller for the difference in price. In some circumstances, the buyer might request specific performance or replevin. We talked about specific performance under common law. Same concept apply for the UCC. The item is so unique that you don't want any compensatory damages. You want the actual item. So under the UCC, the buyer have certain specific rights when it comes to obtaining the goods that they have contracted for, especially those goods that are unique and cannot be easily replaced. These rights are known as specific performance and replevin. Specific performance. Let's talk about specific performance first. Right to specific performance. It's a legal remedy that may be used in sales contract where the goods are so unique or when the buyer cannot reasonably obtain them to obtain a substitute for them. In those situations, the court might order the seller to actually fulfill the contract by delivering the specific goods agreed upon originally. Now remember, under common law, you cannot force the other party to perform because that's a form of slavery. But when it comes to the UCC, you can force them to sell that unique item. You can force them to do that. For example, Emily contracts with an artist for a custom painting for her hotel lobby. The painting is unique and no other painting can match its specific style and significance. If the artist refuses to deliver upon completion, then Emily can seek a court order for specific performance. I want it, requiring the artist to deliver the painting as per contract because it's so unique. Buyer's right to replevin. What is that? It's a legal action that allows a buyer to recover goods that are wrongfully held by the seller. So the seller has them. For example, they were manufacturing something for you. It's done. They segregated them. They have them, but they're holding them. When the goods have been specifically identified in the contract and the buyer cannot reasonably cover by finding a substitute, then you'd say, you know what? You have them. It's my product. You can't ask the court to force them to relieve it. Jacob ordered a rare vintage car from a dealer, and this specific car is identified in the contract. If the dealer decides to keep the car and not deliver it to Jacob, and Jacob cannot find a similar vintage car, he has the right to seek replevin to recover the exact car specified in the contract. How about there's a risk that the seller is going into bankruptcy, insolvent seller. What should you do? Well, when the buyer has made a partial or full payment for goods in the sales contract and the seller becomes insolvent, it means they're going out of business, the buyer has specific rights under the UCC. In those circumstances, if the goods that they purchased, that they paid for, that they made a partial or full payment for, has been distinctly identified as part of the contract, the buyer is entitled to recover these goods from the insolvent seller. Now, why do you want to do that? Because you don't want to go into bankruptcy court. It's going to take longer and you may or may not get your goods. This right is important as it provides a form of protection to the buyer in the event of the seller financials collapse. So the identification of the goods here is a key aspect of this provision. It allows for the specific goods that the buyer has a claim on to be clearly identified and separated from the seller's other asset. Because guess what's going to happen? If you cannot identify it, keep it separately, guess what? Those assets will be sold and they will pay off the debtors. Let's look at an example. A restaurant is the buyer, pays in advance for a custom-made oven from a manufacturer. The oven is specifically designed to meet the restaurant's unique specification and is identified in the sales of contract. Before the oven is delivered, guess what? That manufacturer declared bankruptcy and became insolvent. In this case, the restaurant, having already paid for the oven, has the right to recover the specific item. That's why you want to identify it, despite the manufacturer's insolvency, means they're going out of business. This is because the oven has been specifically identified in the contract, and the restaurants had either partially or fully paid for it. This right helps the restaurant do what? Secure the asset and avoid entangling in the bankruptcy proceeding. Entrusting. What is entrusting? This concept stipulates that if an owner entrusts goods to a merchant, notice here a merchant, who normally deals in that kind, and if the merchant then sells the goods in the normal course of their business to a bona fide purchaser who buys the good in good faith, the purchaser gains legitimate ownership of the good. Let's assume I'm fixing my iPhone. I went to an iPhone iPhone place, and I thought, okay, good. Would you mind fixing my iPhone? Now, after they fixed it, one of the employees made a mistake and put it out there on the shelves. Somebody came in and purchased my iPhone. It's a merchant. They made a purchase with good faith. That's it. They have ownership. This holds true even if the merchant did not have the authority or the right to sell the goods. However, two key conditions must be met for this rule to apply. One, the goods must be entrusted to a merchant, not to your neighbor, not to anyone else. This means a business or individual who deals in these goods on a regular basis, not a non-merchant, like a bank. Because sometimes what you can do, you can place gold, you can place expensive item in the bank. That's different. So the goods has to be with a merchant. Two, the sale must occur in the ordinary course of business. So it was a mistake. Okay, this excludes situation where the seller is making a bulk sale of the merchant's entire stock or liquidating sale. Then they have to be careful. Then they have to be careful about that. Otherwise, the person that buys this item, buy my iPhone, will have it. Example: Sarah owns a valuable painting and she leaves it with Artwork, a gallery that on a regular basis deals with such painting. We're dealing with a merchant. But she left it there only for display purposes. She wants to show her painting. If the gallery let's assume the gallery, for one reason or another, sells it to John by mistake, an unsuspecting customer who believes the gallery owns the painting. Guess what? John acquires the title to the goods, and he owns the painting. This is because John is a buyer, a good faith. This is because John is a bona fide purchaser who bought the painting in good faith. during the ordinary course of business. As far as John is concerned, I purchased it from a place of business. Now, Sarah cannot claim the painting from John, even though the gallery did not actually have the right to sell it. However, if this sale had been part of a bulk sale of Artsword's asset, or if Sarah had entrusted painting to a different type of business, let's assume a bank for safekeeping, the rule would not apply, and John would have to return it, would not gain good title. Let's take a look at this multiple choice question from farhatlectures.com. What happens if a buyer accepts non-conforming goods? Goods that they are not according to the perfect tender. It's not what they expected. It's not what they ordered. Well, A, if they accept, would they lose the right to sue for damages? And the answer is no. If they accept, they could still sue for some sort of damages. They pay extra for the goods. Not at all. Those goods are non-conforming goods. They don't have to pay extra for that. This is an easy elimination. C, they can still sue for the difference in value. Can they do that? And the answer is yes. You could still sue. First of all, you don't have to accept. Even if you accept, you could still sue for the difference in value. So in other words, if the non-conforming goods accepting non-conforming goods does not prevent you from suing for damages. And what will be the damages? It's the difference in value between what was delivered and what was in the contract. So what was in the contract worth $10,000? What was delivered, the value of what's delivered is $8,000. There's a short of $2,000 plus any incidental cost. You can sue for that. C is the correct answer. Let's just make sure D is not the correct answer. D, the buyer automatically agreed to the new contract. Absolutely not. They don't have to agree automatically to the contract. What should you do now? You want to go to Farhat Lectures, look at additional resources, multiple choice questions. That's going to help you do what? Do better, study better for the CPA exam. Study hard. Farhat is always here to help you. Good luck. Study hard and, of course, stay safe.